So when we're talking about estate planning, we always want to look at how assets are owned. At death, assets pass really two ways: through the probate process, through surrogate's court, or outside of surrogate's court in what's called a testamentary substitute. So when we're looking at who you want to receive what, just because your will says everything goes to my three kids equally, if you have all your bank accounts with one of your kids who helps you the most on is the joint owner, at death, it's going to all go to the joint owner. Or if you only have one child as a beneficiary on a life insurance policy, it doesn't matter what your will says, it's going to go to that beneficiary. Will only controls assets in your name alone without joint owners and without beneficiaries named on them. So, just because you have a will, that doesn't assure anything is going to happen with respect to certain assets that may have joint owners or may be held in trust with beneficiary designations or IRAs, life estate deeds, transfer on death designations. All of those are in the non-probate category. They're going to pass outside of the will. So your will could say everything to my one grandchild, but if your three kids are your beneficiaries or one child is a joint owner on most of your property, nothing's going to go through the will. Just because someone is named as executor in a will, they don't have, number one, they don't have any power until the will is probated, meaning the executor goes to a lawyer and they fill out a lot of paperwork, pay a retainer fee, submit documentation to the court, which must include the original will. So that's another one. You do not want to lose that original. I'd recommend you have it on file at the court. And once the court approves the will, they'll give the executor authority to act. No distributions can be made until at least 7 months after the executor is appointed. So we're looking at least a year-long process for this to happen, which makes it very attractive to a lot of clients to try to take steps to avoid the probate process and avoid assets having to pass through their will.
Hey, Frank, it's Angela. Can I ask you a quick question?
Sure.
How do you, if you have an original will and you want to file it with the courts, how do you do that?
You can have your attorney do it for you, or you can go down to the circuit court clerk's office and put it on file. They'll give you a receipt with the page and library number, and it will never be able to be lost. A lot of issues that we run into when people come to administer estates or probate wills is, where's the original? Not only do we need the original, we also need to get affidavits of the witnesses that attested to that original. So you have to track down the document, and then sometimes you have to track down the witnesses, like the secretary that worked for your attorney in 1985. We need to go find her to get stuff signed. When we do wills, we have witnesses sign all documentation they need to sign simultaneously with the will, and we keep that all together with the will, and it's in the circuit court clerk's office. It can't get lost. Doesn't matter if there's a fire. You can't get locked out of a safe deposit box. All the issues that can come up are avoided by putting that original will on file with the clerk's office. So you can do it yourself or have your attorney do it for you. There is no charge in Erie County or Niagara County. Some counties there is a fee to do it, but it's certainly worth it. And with our documents, we insist that it be done.